Next is agreement in restraint to trade. Agreement in restraint to trade means an agreement which stops trade, an agreement which prohibits trade. You cannot enter into agreement wherein you are stopping somebody from trading, wherein you are stopping somebody from entering into business. Like an agreement which is in restraint of marriage, agreement in restraint of trade is also void. We take an example, there's a person P and there's a person Q. P tells Q that I'll give you 10 lakh rupees if you do not do business at all ever in your life. Q accepts it. And again after a month, Q starts his business. Do you think P will be able to enforce this contract on Q and take him out of the business? Do you think P will be able to enforce this contract on Q and take him out of the business? No. P will never be able to enforce this contract on Q, because any such contract which is entered into by two persons stopping the other from entering into business or doing any rendering any service or doing any trading, such a contract is void. The other person will never be bound by such a contract. So you cannot enter into a contract which is in restraint of marriage. Also, you cannot enter into a contract which is in restraint of trade. However, regarding this contract, regarding this agreement, there are some exceptions. That is, if the contract relates to these exceptions, these contracts would be valid. They will not be considered as void. So what are those contracts which are in nature in restraint of trade yet they are valid? First is sale of goodwill. Now let's say the company Cadbury sells its brand, Dairy Milk brand. Dairy Milk has a value in the market, it is a brand, it is a goodwill, because people come and ask the shopkeeper to give them dairy milk. So it has a lot of goodwill in the market. And the company sells this brand to, let's say, Nestle. Do you think after this agreement, Cadbury will be able to continue with this brand Dairy Milk, or it will have to stop its business? Yes, the company Cadbury will have to stop its business. Whatever business relates to the brand Dairy Milk, it cannot go on producing Dairy Milk chocolates anymore. So this is a contract wherein it has sold its goodwill to Nestle. Nestle can ask Cadbury to not to produce Dairy Milk chocolates anymore. So you cannot say Nestle would be unreasonable in asking Cadbury to stop production. Such a contract is in restraint of trade, so it will be void. No, such a contract would be valid, because otherwise it defeats the purpose of purchasing the brand by Nestle. Why would Nestle purchase the brand? If Cadbury is to continue the business, then what is the purpose of purchasing the brand? It defeats the purpose. So whenever you sell goodwill, you'll have to stop that business and it will be a valid contract. The next point is partnership. You are a partnership, that is why you are into the partnership, and also when you have retired out of the partnership or the firm has been dissolved, in both the cases you may be asked to not to do the business which the partnership was doing. While you are a partner in the partnership firm, it is pretty much logical to understand that you cannot do a competitive business. Otherwise, you start your own business, don't be into the partnership firm. So when you are a partner, you cannot engage into a same business. The firm can't ask you to stop the business if you are doing it, or it can ask you to not to get into that business at first place. So such a contract would be valid. Even though it would be a contract in restraint of trade, it would be valid. Now coming to the second case wherein the partner has retired or the firm has been dissolved. Now if the partner has retired from the firm, he is no longer a partner. So ideally he can start his own business which may be of the nature which is competing with the business of the firm. But here the firm may impose a condition for the retirement of the partner that after retirement you will not enter into the same business. So this will become an agreement in restraint of trade, yet it will be valid. The point to remember here is the condition that the firm imposes on the outgoing partner has to be reasonable. The firm cannot impose a condition saying you cannot ever enter into the contract. The firm cannot impose a condition saying you cannot enter into the business of the firm anywhere in the world. It has to specify limits. Let's say you will not do this kind of a business within a radius of 5 kilometers from the place of business of the firm, or you will not do the same kind of a business for the next 6 months. So these conditions are reasonable and firm can impose only reasonable conditions. Unreasonable conditions will make the contract void. The next is exclusive dealing agreements. Exclusive dealing agreements are normally entered with the single sellers. The company appoints a single distributor, a single seller. He is the exclusive dealer of the company. So we say that he has the mandate to sell the products of the company. Now he signs an agreement with the company that since I am the only seller or the distributor of, or the agent of the company, you will not appoint any other person as your agent, as your dealer. I should only get the exclusive rights of selling your products. So he is stopping the company from entering into business contracts with other sellers. At the same time, the company may also impose a condition on him saying, since you are the only seller of the company, we want you to be an exclusive seller of the company products only. We do not want you to sell the products of other companies also. So both of them can impose conditions on each other. These conditions, these contracts would be in restraint of trade, yet they'll be valid considering the nature of the contracts. Restraint among employees. Now, again, there can be two cases like the partner. While the employee is in service or possibly after service. While the employee is in service, the company may ask him to not to work for anybody else. You are working for us, so you will have to work for us full time. You cannot work for anybody else. Or possibly you cannot start your own business. Since you are in the employment of the company, you have to give all your attention and channelize all your energies in doing the work of the company. You cannot do the business. So the company is imposing restrictions. Such a restriction would form, if the employee agrees, they will be getting into an agreement which is restraining trade on the part of the employee. Yet this agreement would be valid. Now coming to the second case, even though the employee has left the service, the company might impose conditions on him to not to enter into the same line of business, to not to cater to the same clients, to not to sell his products or service in the same area. But these conditions have to be reasonable. This is almost similar to the second point wherein we discussed that the conditions imposed on partners should be reasonable. Likewise, the conditions imposed on the employees should be reasonable. They should specify the time limit or the geographical limit. Such conditions would be considered reasonable and the agreement would be considered as valid even though it restrains trade. Now we have a question for you on this. S, a seller of imitation jewelry, sells his business to B and promises not to carry on business in imitation jewelry and real jewelry. The agreement is A, fully valid, B, valid with regard to imitation jewelry and void as regards to real jewelry, C, void with regards to imitation jewelry and valid as regards to real jewelry, D, wholly void. Here the answer is B. You have to understand that S has sold his business. His business was of imitation jewelry. So B purchased the business of imitation jewelry from S. So B can only impose a restriction on the trade of imitation jewelry, which A has accepted and he has restrained which S has accepted and restrained himself from doing. However, if S does a business of real jewelry, that would be valid, and B cannot stop him from doing a business of real jewelry because the condition has to be reasonable. You cannot ask S to not to do business, be it of imitation jewelry or of real jewelry, because his business earlier was not of real jewelry. So now he cannot stop him from doing the business of real jewelry. So the contract will be valid with regards to imitation jewelry. That is fine. That is reasonable. However, as far as real jewelry is concerned, that business S can always do, and if B has entered into an agreement to stop him from doing that, that part of contract would be void. Second, in which of the following agreements restraint of trade is valid? A. Agreement with buyer of goodwill. B. Trade combinations to the extent they do not create monopoly or oppose to public policy. C. Agreements under the Partnership Act 1932. D. All the options. Here it will be all the options, because when you sell goodwill, restraint of trade is valid, we have studied. When you enter into partnership, agreements in restraint of trade is valid. We have also studied that if you are entering into trade combination, that is you are purchasing some company, but you are not creating any monopoly or you are not doing any business which is opposed to public policy, that is also valid. So in this case, all the combinations are valid. All the options are correct. Next is execution of a bond requiring employees leaving the organization before the expiry of the term of service to pay compensation to the employer is considered A. Unenforceable agreement, B. Voidable agreement, C. Valid agreement, D. Void agreement. The answer here is the agreement is valid. The employer can put reasonable restrictions on the employee even though he has left the organization, and while he is serving, even then he can also put a condition of the expiry of the term of the service. So these conditions can be imposed by the employer on the employee, so the agreement becomes valid.